Cheryl focuses her practice and the representation of employers in labor and employment matters, including litigation. How about the overtime rules? Title VII and retaliatory cases. In addition, Ms. Wilke provides comprehensive risk management programs for clients. She counsels on all aspects of employer-employee relations, including business litigation, regulatory compliance, employment defense litigation, and workers' compensation matters. Ms. Wilke also practices in the area of high-dollar commercial litigation and collections and services. And with that, by the way, Ms. Wilke also mentioned to me that she is comfortable and prefers that you do ask questions as you go along. If you'll hold your question off until the microphone gets to you, Michelle Springer in the background has the microphone, and she'll be running around asking, putting that microphone in your face, but hold off on your question. Just raise your hand. She'll get the mic because the program is being recorded and your colleagues can't hear you with the acoustics in this room. Okay? Cheryl?
Thank you.
You bet.
Well, good afternoon, everybody. My name is Cheryl Wilke, as indicated, and this is the third year that I've had the privilege of speaking for you. It's always one of my favorite events of the year. I speak about 150 times a year at various functions and all over the world. I did employment training, EEOC training for Oracle in Dubai a couple weeks ago, so I'm still trying to figure out all the jet lag. But this particular year, I was even more excited to be here. I spent the last 4 days, in our last class, I attended the last class, there were some people from Arizona. Is there anybody from Arizona in here? Oh, good. So do you know where Florence, Arizona is? Okay. Florence, Arizona, for those of you who have never had the privilege, is the prison town for the state of Arizona. And there are 7 prisons there, and I've just spent the last 4 days doing EEOC training for prison guards in the prison which was designated as the prison for criminal sex offenders. I cannot begin to tell you how happy I am to be out of lovely Florence, Arizona. I also had the privilege of staying for 3 blissful nights at the Holiday Inn Express in Florence, Arizona, which is their luxury hotel. And so the first thing, of course, when I got here that I did is ordered room service, took a hot shower, and made sure the sheets were clean. So I am very, very happy to be here. My job today, though, now that I am no longer in Florence, Arizona, teaching to prison guards, is to help you as business owners navigate employment. Now, I have an hour and 10 minutes. I could be here for 16 hours, but I'm going to try to tailor this exactly to you. That means that I absolutely want you to ask questions because I don't want to spend time on stuff that either you know or it is not terribly important to you. So let's get started. The hiring process. I know that you all are in business to sell and finance cars. Hiring people sounds so much easier than it really is, both legally and factually. Sales is a difficult business to start with. Independent sales can be even more stressful, and oftentimes the employment rules that work perfectly fine for Starbucks and Walmart don't translate very well by economies of scale to your size business, even though they all apply to everybody the same, whether you're Walmart or you have 15 or more employees working for you. My recommendation is that hiring always starts with the job posting. I can't tell you how many times I've seen car dealers. I live in South Florida. I live in Boca Raton. My firm is headquartered in Chicago, but my office is in Fort Lauderdale. And I represent a lot of dealerships in Florida, both flag, independent and not, and with flags. And invariably, when I read the paper or when I see ads on Monster.com, not for my clients, because I won't let them do this, but invariably I see something that says in the job posting, earn $60,000 a year your first year, no problem. That is always the wrong thing to do in a job posting. Any of you from California? Okay, if you put that in a job posting, it can actually be considered a contract of employment in certain times in the state of California. California, we're going to separate out California from a lot. For those of you from California, I'm admitted to practice. I actually spent 3 blissful days taking the bar exam in California, and clearly someone intoxicated reviewed my exam because I passed the first time. So I do also practice in California. Because the laws in California are so unique, I will highlight those laws for you gentlemen in particular. So use job descriptions for consistency. If you're posting a job description for a salesperson in February, in June, or December, it should basically say the same thing. I see a lot of people who think they can jazz them up or change them. It's important that you keep them consistent. Post in the right places, you know, and sometimes that's hard to figure out. We'll talk about the monster and monster.com in a minute. Use vocational and college placement and technical schools to reduce your recruiting costs. For those of you especially who are in smaller communities where vocational schools, they love to post your jobs. They are delighted to do it for free. They will coordinate the appointments. They will bring the people over. They'll provide transportation. They'll do job fairs for you. Use the resources in your community before you spend huge amounts of money recruiting. Community colleges, vocational schools are really some of the very, very best place for you all to do some recruiting. People who have decided to get into marketing or business, whatever it is, and a lot of times they will go to those schools and not really know what they want to do, but you, the recruiters there, the placement officers are delighted when a business like yours comes in and says, we're looking for we're looking for salespeople, we'll train. They will send you, you tell them exactly what you're looking for and they'll send you the best and the brightest. Saves you a lot of time and a lot of money and a lot of grief. They'll show up at the doorstep, they'll set the appointments. It can really be a wonderful opportunity. Understand the difference between posting for a job and posting for a career. I'm in an in-between generation. I'm not a Generation Xer and I'm younger than a baby boomer, so I'm kind of in an in-between age that doesn't really have a title. But one of the things that many of you who are recruiting may note that anybody who graduated from high school after 1990 considers a job to be a stint, not a career. Everybody's laughing. You've seen this movie? Yeah. There is a natural, it is just simply the evolution of jobs. I have the privilege of representing Kellogg's. And in case you've ever had a Pop-Tart, they're all made in a delightful place called Pikeville, Kentucky, because besides Florence, Arizona, I also get to go to places like Pikeville, Kentucky, because my job is so glamorous and sexy, as you can see. And in Pikeville, Kentucky, they make Pop-Tarts, and they have been making Pop-Tarts since 1927. There are 4, sometimes 5 generations of people who have never worked within a family any place else but Kellogg's. That is the last of that type of employer. Your type of employment is the employment of the future. If you want someone to apply for a career, post it like a career. We are searching for someone with long-term commitment to seek out a career in professional sales. If you post for a job, you'll get people looking for a stint. If you post for a career, hopefully you'll get people who are more interested in a much longer duration of employment. Understand the difference, is less more in a job posting? Yes, yes. We do this, we're open this. No. We are looking for qualified, entry level, whatever the job is. We would like you to come in and talk to us about the opportunities. We are community-based, family-run, local business, however you want to classify yourself. We are anxious to speak with you if you are looking for a career with opportunity for growth and promotion. For those of you in California, if you put in anything more, they will use it against you. Be very, very careful in how you do your postings. The use of the internet, the monster and monster.com. I just spent a lot of time listening to the wonderful speakers about auctions and about how they don't always get what they think they're getting on online auctions, which I think is fascinating because it's exactly the same thing when people apply for jobs. So the pros of using online recruiting are it's easy. It used to be that you had to, remember your newspaper where they would only post on Tuesdays and you had to pay X number of dollars and then it wouldn't start running, the ad wouldn't start running until the following Wednesday and it would run for 3 days and if you forgot to renew it, you'd have to go back in. They don't do that anymore. It's extremely easy now to post a job. Very cost effective. You can reach everybody who has access to the internet for the exact same price. How cool is that? You're not limited to just the radius where where your local newspaper goes. It's instant. You don't have to wait till next Tuesday till the paper comes out, whatever it is. You have a wide range of territories and job areas, and you get to pick who you interview. It's not like you're saying, well, everybody come on in and we'll, a job fair. And job fairs have their value, but the good thing is that with the internet, you can do preliminary screening. The cons, way too much bad information. I always say that this is remarkably like a dating site. Really it is. Here's the bottom line. It isn't necessarily that people lie. They do. but they tend to embellish some of the finer qualities of their previous jobs. Like I saw one, and this was not in the car dealer business, but a woman was applying for a production manager at a factory, and she put down that she had changed from her last two jobs because she felt that her leadership options were very limited. Well, yes, they were, because she was fired from both of them. So yes, she was not going to have leadership options because she was in fact fired. So no, you don't have leadership options if you can't make it through the first stage. Garbage in, garbage out. You know, if you post for something, if you don't put the posting up right, you're going to get stuff that responds to that post even though that wasn't what you were thinking. Predators are looking for claims. I'm only going to talk about this for a minute, but I have seen it happen in your industry, mostly at the flags, but sometimes with you. There is a group of very unscrupulous people out there who file what's called Americans with Disabilities Act claims. And what they do is they search for employers like you who are posting on the internet, and they send in a resume. The resume looks awesome. You say that you would like them to come in for an interview. When you do that, you will get an email back that says, "Thank you very much. I'm looking forward to interviewing with you. Oh, by the way," and I'll use the example that actually happened, "I have a vascular issue, and I cannot wear shoes. I wear slippers. Will that be a problem?" Okay. Now, in the case that I was hired to defend, my client, who's just wonderful, did what a lot of people's first reaction is, which is, "Of course not. Please come in. We'll be happy to evaluate you on your credentials." And that is your first radar. That's what everybody thinks they're supposed to do. The person comes in, is ultimately not hired. There's somebody else that has equal qualifications. The person who was not hired but who did get the interview comes in and files an Americans with Disabilities Act case saying the only reason he wasn't hired is because he was the only person who applied with a disclosed disability. And even though that is not the reason you didn't hire that person, do not fool yourself. Those predators are out there. For those of you in California, they grow on trees. Truly. The best way to do something is that if somebody extends or someone responds to you and says that they have a disability, you provide them with an email back saying, "Thank you very much. Here are the essential functions of this job." And you list every physical demand that that job could ever have: standing, walking, bending, stooping, the hours, the days, everything. If they still want to come in, and they won't, then you deal with it. But I have never had a person come in after disclosing a disability who said, "Oh yes, I can perform all these essential functions of the job." Because if they say yes and come in for the interview, they don't have a legal claim. Their claim is exhausted. I've only seen a few of these in the car industry. Where I really see them is in finance, people applying for finance jobs, more sedentary jobs than sales jobs, but I've defended one directly and I've seen four from my clients. You can make this a two-step process. You can get the information, then conduct the interview. Unlike a job fair where you're trying to get everything together at the same time, or people walk in off the street and say, "I want to apply," you're kind of stuck doing everything at the same time. You want to make sure that you have the time to evaluate the information before you waste your time conducting interviews. You guys there's simply not enough hours in the day for you to do everything that you can do. The less time you have to spend on poor candidates, the better it is. Here's one of the, and that should say my grammar police did not quite catch that. Your competitors can see what you are looking for and price accordingly. This happens primarily in service. I have seen it happen where I represent a Cadillac dealership in Palm Beach County. They had a big problem with some service people. There was big disputes. 7 of them left on the same day. They just quit and walked out and all of that. And so the dealership, thinking that they were doing the right thing, put this big ad in the paper about how they were growing and they were looking for service advisors, and they made this big fuss about what they were looking for. Well, come to find out, one of the other Cadillac dealerships saw that ad and said, "If you would like to have your car serviced in 30 minutes or less, please see us. We are fully staffed. We have service techs available for you, and we guarantee you that you will wait no more than 20 minutes for your car to be accepted, and your appointment will be." So the competitor saw that and took advantage of the fact that they could figure out from the job posting what the problems were. What you see is not what you get. See, your internet vision is that you're going to get Brad Pitt, What shows up is John Clayton, who I'm sure is he's actually a reporter for ESPN. I just added him in there, but I think that that's a pretty good summary of what you think you're getting and kind of what you get sometimes. So, key rules for hiring right. Use one application only. That means that if you are going to use an online application, if you're going to use an online application, make sure that it's exactly the same as your mail-in and exactly the same as the resume or the application that they pick up when they go there. I know that some of you use the applications that are provided by the online provider, whether that's Monster and Career Builder or whatever. You do not want there to be, you don't have to do that. You tell them this is the application I want to use. If you use theirs, you are going to end up in a situation where you're getting apples and oranges and not apples and apples. More importantly, they're not going to ask necessarily the specific questions that you're going to want on your applications. Ensure that none of your application materials make reference to protected classifications unless it's a requirement for the job. For example, if you're going to have a porter, someone who needs to have either a limousine license or a CDL, whatever it is in your particular state, obviously there's different age requirements for that. That's perfectly fine. You can ask that. Otherwise, we're looking for people between 35 and 45. No. No age, no race, no sex, none of that stuff. None of that stuff should ever go in your posting or your application. Notify prospective employees if they are subject to drug testing. I will tell you that if it's on the application, acknowledge that you understand you will be tested for drugs or alcohol at the time of your interview. You should see how few interviews you get that end up being problematic. So I always have that as part. It should be part of the disclosure part. It should be disclosed as part of the application process. You should not wait till the interview. All right. Designate 2 people to conduct interviews for a particular position. There should be somebody from the business side. Usually this is on HR. Can be anybody you designate. Sometimes it's a controller. Sometimes it's a business manager, however your business is set up. And then, of course, there should be somebody who's specific to the job, someone who knows the technical aspects of what you're looking for and who you're hiring for that position. Here's the big one. Never, ever, ever make any promises as to the length of the process, the method of communication, or the salary at the initial interview. Here's the best way to lose the best applicant you're ever going to have. It's been a great interview. I want to thank you very much. We're going to let you know by Thursday. Okay. And then what happens? Everything happens. And you don't get around to it on Thursday. So you've made a promise. They've perceived that since you didn't report back to them until Monday that you've broken your promise, and in all likelihood you have lost that applicant. So I recommend that you say something along the lines of, we expect to be making a decision within the next few days. Few days is fine. Nice and general. You're not being too specific. We expect to be making a decision within the next week. We are looking at everything. Our last date for submission of applications is Wednesday. We'll be making a decision after that. So you're not nailing yourself down. And although a lot of applicants in your business, I actually had an applicant, I was doing some hiring for a client, and the applicant said, and I was going through his job set, his job skills, and every time I came to a job skill, his answer was, well, just pay me and I can do that. Okay. Not a good applicant. And he didn't pass the creepy test to start with, but nonetheless, I never allow an interviewee to dictate the salary terms. So if they come to you and they say, well, I'm really excited about being here and everything, but I'm not interested in this interview unless you're paying X, thank them very much and let them go, especially you folks in California. If that's their demand when they walk in the door, that's probably not the right person. Sometimes they think that because it's a sales job, they're showing sales initiative and all that other stuff. I disagree with that. I usually say, thank you, we're delighted to have you too. We understand what your salary requirements are, and we'll be notifying you if we can meet them. You take control of that interview. If you let the applicant take care of the interview at the time, especially with salary, it's very tough to get that control back. Okay. On May 1st of 2012, the Equal Employment Opportunity Commission passed new rules regarding the use of criminal background checks by employers. The background checks cannot result in discrimination based on race or national origin, even if race is neutral on its face. This is what they said. The EEOC said to Coca-Cola in Georgia that they did not hire a disproportionate number of people who were African American and Hispanic because they had a blanket application that said, we do not hire felons. If you've been convicted of a felony within the last 10 years, you are not eligible for hire at Coca-Cola. Even though that's neutral on its face, meaning it doesn't say if you're African American or Asian or blue or green or purple or whatever need not apply, what ended up happening is that it impacted a disproportionate number of people who were black and Hispanic. The EEOC came in and said, you cannot do that. You have to make sure that you at least listen and you hear what the felony is and you determine whether or not it's specific to the job and whether or not it can impact the job. You simply cannot have a line on your application that says, you know, have you ever been convicted of a felony, and that's an automatic exclusion. I will tell you that I don't write the laws, I just talk about them. This one's uncomfortable for me because it doesn't make a lot of sense. Nonetheless, the good news is it doesn't really apply to you guys. And this is why. Because there's specific exceptions. Anyone who deals with keys, checks, or cash, it is still perfectly okay to do a background check. And almost everybody that's going to work with you or for you, besides maybe the guy who paints the signs on the windows that says about the sales, is probably going to touch keys, cash, or checks. So for the most part, you all do not need to be terribly concerned about these new regulations because they're just not going to impact you. The way your business works, almost from the porters to the techs, obviously to the salespeople, they all touch keys. So that's the good news. Credit checks, less restrictions on criminal checks. On credit checks, I'm sorry. Employers are allowed to consider prior bankruptcies as part of the hiring process, except if you're in these three states. You can never use a bankruptcy filing to fire an existing employee in any state. There is actually a portion of the bankruptcy code that says that if you have an employee and that employee discloses to you or you find out otherwise that they have filed for bankruptcy, it is a discrimination claim to fire them for that reason only. And that is true in all 50 states. I get these claims from time to time. I got a lot of them in 2010 and 2011 when people were really suffering and they were filing bankruptcies and people were, mostly banks, were firing people. It doesn't matter what the job is. You cannot fire somebody in the United States exclusively because they have filed for bankruptcy. That is not a legitimate reason. Again, use cautiously if you have someone who's going to be using cash checks or keys, especially your finance people. If you want to do credit checks, you can. If you have any fiduciary employee, and by that I mean someone who can sign checks or bind the company, so if you've got partners and everything, you should definitely have credit checks, and of course, to the extent that you are able to, have people have bonds, fidelity bonds, so that if there is something that goes wrong or they found the woman of their dreams online and they're leaving with all of your cash receipts, you have some tool to get that money back. Here are the proper questions under the Americans with Disabilities Act that you can always ask. You can always ask, can you perform the essential functions of the job all day, every day, without a problem? You never use what you see to solicit questions. So we saw our lovely host today hobbling around with his little cane, making everybody feel sorry for him, kind of, sort of. If someone like that were to come into your business and say, I want a job as a tech, you can't simply look at him and say, well, you have a cane, you can't be back there with it. You're not allowed to use what you see to ask additional questions. Okay. Cannot ask about prior workers' compensation cases as part of the hiring process, but I am here to tell you that every state now has a database that is open and it is public, and you can go online and see who's filed workers' compensation cases and make sure you're not hiring a serial workers' compensation claimant. The problem with the databases is they are state-specific, meaning if you've got somebody who's relocated from 2 or 3 different states, you've got to check 2 or 3 different states. But they're usually very easy to access, and it's all public, and you can look at it all, and no one's going to know you ever looked at it. It's okay. You can do that. After a job is offered, an employee requests an accommodation. The interactive process is required. So you've hired somebody. Everything is easy peasy, not a problem. They come into you, and they say, on my lunch hour, I need to use a respirator, a nebulizer, I have an asthmatic condition. At that point, you say, okay, we have a room that's private where you can do that on your lunch hour. It won't interfere your work. That's an accommodation that you can make afterwards, because it does not impact the essential functions of the job, because the only time the disability is relevant is during the person's lunch hour. So that would be something that you would need to accommodate under the Americans with Disabilities Act. All right, pay plans. I love my clients. I love all my clients. You're my only clients that use these. It makes life so complicated sometimes. Pay plans are a unique function of the automobile sales industry. I have no other industry who uses pay plans. Not structured. Some of them have sales contracts. Some of them use different things, but you guys are the ones who use pay plans. In right-to-work states, there are always issues of whether pay plans become employment contracts. Are you paying for sales? Are you paying for management? Are you paying for training? We'll talk about all these issues in a second. There are always issues of shared commission. Is that a car? Meaning what was sold, who sold it, when they sold it. I can't tell you how many fights I settle having to do with split commissions and all of that. And of course, recouping pay plan draws. These are the big issues. I'm happy to talk about any of the other ones that you all specifically have, but these are the ones that I gleaned from your colleagues when I was putting this presentation together. So let's talk about these. On every single pay plan that you have, except you folks in California, because you can't do this, in every single state other than California, the top of your pay plan should say in big, bold letters, this is not an employment contract. All of them. Every pay plan that you have. I don't care if it's for a tech, I don't care if it's for a salesperson, I don't care if it's for finance. Every single one should say on the top, this is not a contract of employment. It should clearly define if there's commissions for sales and define sales. Define what the margin has to be to qualify for commission, discuss whether or not they get extra for if the car is financed, whether or not there are supplemental sales, meaning that do they get credit if the person comes back and buys another car for that repeat customer. All of these issues come up from time to time. Address training time, administration time, and management time. Are they going to be compensated by the hour, or are they not going to be compensated at all? How are you going to do it? I don't care. Legally, it really doesn't matter. You just have to disclose it. Do whatever you want. You can still negotiate it however you please, but address it. If you leave it empty, or if you don't discuss it, that's where the litigation comes in. Well, I didn't get paid for all that training time. I worked. Violates the Fair Labor Standards Act. I didn't get paid for that. I didn't get minimum wage for that time when I was required to work. Make sure you spell it out. Have defined enforced true-ups for advances paid but not covered by commission. I'm not going to ask for a show of hands because I'm not going to embarrass anybody, but here who has been stuck by someone where they have paid advance commissions and things didn't work out, or the employee left and they left you hanging the bag for advance commissions that you've never recouped from their sales. Okay, I can see all the faces. I won't say anything. It'll be our secret. Have true-ups spelled out in your pay plans how you're going to true up. If you pay advance commissions, figure out how you want to do your true-ups and when, and stick to it. I absolutely positively recommend that you do not go longer than 90 days. If you are going longer than 90 days on a true-up, you are going to get burned. They are going to leave and you are never going to get the money back that you've advanced, that they've never actually earned in commission. Always, always pay minimum wage for hours worked. You all are extremely, again, another unique function of you. Car sales are specifically excluded from the provision of the Fair Labor Standards Act that says you have to pay overtime. You do not have to pay overtime. You are specifically not excluded from the provision of the Fair Labor Standards Act that says you have to pay minimum wage. So when you're doing your draws, when you're calculating your draws, if it is based on a 50-hour work week, you better make sure that it's 50 hours times your minimum wage for your state. Now, I gave to Georgia a handout that has the minimum wage rates for each state. I have a couple copies with me, but you can get them online from the Department of Labor and you can find out exactly what that is. But remember, you all are not exempted from the minimum wage, the hourly minimum wage, only from provision of overtime. Again, this does not apply to my California people. Your Fair Labor Standards Act is off the scale. California, just so that you wake up every morning and aren't jealous of the fact that they get sunshine 300 days a year and live with movie stars. It's the only state in the country that measures overtime based on a day, an 8-hour day instead of a 40-hour work week. So if you work 8 hours and 15 minutes in the state of California, you're entitled to 15 minutes of overtime for that day. It is also the only state in the country that forces employers to mandate and enforce lunch hours. So you have to go babysit. When you're in California, you have to take all your employees and say, okay, you have to take lunch now. Go in the playroom and have lunch for an hour and then come back to work. So it's a very difficult state for business. I'm not sure what they think they're accomplishing. I've moved four large businesses out of California recently, 2 to Idaho, of all crazy places, 1 to Washington and 1 to Oregon, just because they couldn't deal with the work restrictions in California any longer. Again, car sales are specifically excluded from the requirement to pay overtime for hours worked over salespeople, but they are required to pay minimum wage. How to calculate? You take your advance, wages plus commission, not subject to recruitment. So what you do is, let's say that you're going to have them work 50 hours a week, and the minimum wage, let's just use $10 an hour. So you're paying an advance commission of $500 a week. Fine. You're covered by the Fair Labor Standards Act. If their commission that week is $600, great, you give them $100. If their commission is $400, then you have to keep track of your true-up, because you still have to pay them the $500. The law says you still have to pay them the minimum wage for the hours that they actually worked. Okay, how do you keep the best employees? Be fair and transparent. For those of you who were at the presentation before, one of the big issues about auctions was the people who are buying the cars want more transparency, whether it's inline or online. I learned new phrases today. Inline, I don't deal with auctions very much, but inline or online, they want more transparency. They want more pictures and more these ratings, and they want them to be accurate, and they want transparency. Well, you should feel exactly the same way about how you treat your employees and how you pay them. Have an employee handbook, which applies equally to everyone. It doesn't have to be more than 7-8 pages, but have one so that it's crystal clear what everyone is required to do and what you expect from them. Ensure your promotion and salary process is fair and based on merit, not on who you know. This
Cheryl?
doesn't have, what?
Hi. Hi, I was in a meeting the other day.
Hop along. Yeah.
How are you doing?
Yeah.
That's my cane, by the way. One of the dealers had asked me about, he thought he had legal advice saying not to have an employee handbook. His attorney actually advised him not to have an employee handbook, which didn't make a lot of sense to me, other than the fact I do understand some attorneys are afraid that whatever you put in the book is also able to be used against you.
An employee handbook is required for people like you because you need to have, here's my recommendation. You all have pay plans. Those are basically, and I'm going to use this word not in a legal term, but those are actually your performance requirements for your employee. So performance is, and those will be individual, they'll be unique, sometimes they're unique for each salesperson, not a problem. But then you have to have policies. What if they're late? What if they smoke when they're not supposed to? What if they don't treat customers appropriately? What if they arrive and they're not wearing the appropriate outfit? Whatever it is, you need to have a handbook that addresses the policy side so that you have a tool to separate people who don't abide by the policy. If you don't have a handbook, all they keep saying is, but look, I make my targets, I satisfy my pay plan. So I acknowledge that you probably should not have a handbook that goes into extensive detail about performance, because you guys are going to carve that out. You absolutely have to have a handbook that says you will not discriminate against your co-employees. If you assault a co-employee, it's immediate grounds for termination. You have to have policy information in your handbook. And I don't care what employer you are, everybody has to do that.
And the last thing I'll leave you with is on the lunch issue. I also had dealers in various states I travel to, and you hear different comments. The reluctance to, well, dealerships traditionally, in many cases, for many years, have always bought their employees lunch on Saturday. Mm-hmm. And the expectation was, I bought you lunch, and I expect you to weigh my customers, not leave the dealership. Is there any level of expectation that they're entitled to a certain period of time of lunch without work?
Only if you're in California. Yeah. If you're in a right-to-work state, Florida, Alabama, Texas, a lot of southern states, thank you, sir. There is no expectation of a lunch hour. You get into union states, I states and square states, I say, which will be Iowa, Illinois, Indiana, those states up there. Some of them say if you have a certain number of employees, which is usually 50, and I doubt many of you will have necessarily more than that employees working at the same time, not just 50 employees generally, but working at the same time. There's usually a half-hour mandated for lunch and 2 10-minute breaks. That's very state-specific, but even then, it's not mandated and it's not an expectation. It's how you pay them. So if you pay them for 8 hours, they're entitled to a 30-minute break and 2 10-minute breaks. If you don't pay for lunch hours, meaning you have them clock in and clock out, or however you do it, then there is no expectation. So it really, you can't create a problem by simply bringing in lunch on a Saturday or bringing in donuts on Fridays. That's perfectly okay. Where a lot of employers get kind of sideways with this is that they will, they'll do something, they'll ask an employee who is not a salesperson, sometimes an administrative person, to stop and pick up lunch or pick up breakfast on their way in. And a lot of times I've seen those, usually young women, but they can be anybody, say that they're entitled to be paid for that pickup time, even though they haven't come to work yet. That's where you sometimes see that issue. So, ensure that your promotion and salary process is fair and based on merit, not on who you know. Obviously, if you've got your brother-in-law working there, that can be a little bit tenacious, but for the most part, promotion and salary should be based on merit. Use annual reviews consistently. Keep benefits, vacation pay, PTO, whatever you offer based on a yearly schedule instead of date of hire. That's just a convenience for you all. So it's easier to prorate for one if you hire in the middle of the year rather than have to do these reviews if someone was hired in April and June, and then all you spend your time is doing reviews and figuring out people's benefits. So do it on an annual basis. I don't care what day you pick, June 1st to June 1st, January 1st to January 1st, but everybody should have the same date for their evaluation. You'll be prorating for certain individual employees, but you only have to do that for the first year. After that, everybody's on the same schedule. Make your life a lot easier as employers. You know, allow employees to participate in their own future. From time to time, have one of those Saturday luncheons and say, what can we do better? How can I help you do your job better? I do a lot of work for Amazon and in the fulfillment centers, which really do have those drones. It's a little creepy. There is someone who is designated every week, an employee who is designated every week, who's on the floor with everybody else. They're not doing anything different, but they wear a vest, and on the back of the vest it says, ask me. And that person is the person that other employees can come up and ask questions, and then it gets filtered if it needs to go to management or whatever. They're empowering somebody in the day-to-day workforce to have some responsibility. Now, I'm looking at all of you, and I can see that, you know, one of the reasons I love coming here is the different ages and the geographies and the diversity of the group. But as employers, how can you tell from looking at a room full of employees who your next leader is? Does anybody have any keys? You can look in a room of your employees. Tell me who, when you look at your room of employees, how do you pick out the person who's going to be your next leader? Who's your best leader? Go ahead. Hold on. Michelle has to run in these absolutely stellar heels all the way up here, so give her just 1 second.
If that's the person that everybody goes to and asks questions.
Actually,
that's how I got my promotion.
Yeah, actually, that's good. It's very similar to that. I'm just going to word it a little differently. I do a lot of leadership training. And one of the things that I see, and I think it applies to every business, is if you have an employee who treats the janitor exactly the same as the owner, you probably have your leader. The worst person that you can promote is the person who manages up. You know what I'm talking about? We've all worked for these people. The people who are right here, they're right in the middle, and they're really great to the people above. They're awesome to them, and they treat the people below them like garbage. We've all seen that movie, yeah? Those are never going to be leaders. They may get a certain level, and they may be okay today or tomorrow or next week, but that's not your leader. Your leader is the person who treats the CEO exactly the same way as the janitor, all day, every day. Here are the current trends. When I was here 2 years ago, I saw all kinds of retaliation claims, and I spent some time talking to you about retaliation claims. Now I can tell you that I have 3,056 open litigated cases around the country that 18 different associates and partners work on with me for any number of hundreds of employers. 1/3 of those cases now involve alleged hostile work environments created by bullying. You can trace that to a bunch of things that are going on socially. It's always amazing to me how the social trends, the news trends that you hear end up translating into your work trends. When you listen to all these stories about these horrific shootings, and again, it's not a political issue with me. I don't care. I'm the most apolitical person in the world. But one of the things that you may, well, I'll ask you, what is the one thing, especially regarding the young men who've been accused of these shootings who are, late teens, early 20s? Is there one common denominator when they write those little letters or post those emails that they all reference? That they were bullied, that they were picked on. And that is translating into the workforce. Does anybody know, how many of you are from Florida? I know I've got a couple. Yeah, I've got a few. What was the big story in Florida that hit all the papers and ESPN and everything else about bullying? Jonathan Martin, professional football player, Miami Dolphins football player, 6'6" tall, 440 pounds, whatever he was. 4 years college education from Stanford. Mother is a psychiatrist. Father is the chief bond trader for Goldman Sachs. Pretty successful family. He happens to be biracial. Gets drafted by the Miami Dolphins in the 4th round, goes into Miami, and truly is treated horribly. I don't care who you are. And by another football player named Richie Incognito, big white guy who picked on him and said all kinds of obnoxious things, including 1,031 text messages where he reported things he wanted to do to his sister and his mother, and I won't even bother with the details because they're not even for good company. And the coaches, the people who should have been stopping this, were saying, we don't think that Jonathan Martin is tough enough. You should go make him tougher. And then when Jonathan Martin finally can't stand it anymore and is this close to an emotional breakdown, he walks away from a $3.5 million a year job and goes back to Stanford. Do you walk away from a $3.5 million a year job if everything is roses and sunshine? So he walks away, and now I realize that the people who call into talk radio in Miami are not rocket scientists, but I'm expecting that the people who are going to call in are going to support Jonathan Martin. They're going to say, this is horrible, this is bullying, this is not that we're a diverse city. We're one of the most diverse cities in the world. We don't treat our people like this. No. Some idiot actually called in and said, well, I don't understand what the problem is. He's 6 foot whatever. He could just beat him up. That's the answer? We're going to let our employees beat it out of each other? They can't be bullied because you're 6 foot whatever? Bullying is not about size. It's not about intimidation of size. It's about emotional intimidation. And then what happened? So Rich Incognito gets kicked off the team. His teammates rally around him, which again amazes me. And again, some brain surgeon on the Miami Dolphins actually stood up and said, well, Jonathan Martin always was a bit of a sissy. I haven't heard that word since I was 6. Are you seriously going to use that on ESPN? Is that what you're going to say? That's what you want people to know you for, is calling one of your professional colleagues a sissy on national television? And of course, the Dolphins managed to lose the next 6 out of 7 games, which they probably would have done anyway based on history. But nonetheless, it's made all the papers, was a big story. I get a telephone call from the general counsel of the Miami Dolphins, who I went to law school with, and his name's Tom, and he calls me and he says, Cheryl, says, you know how you've always been asking about maybe getting involved in some of our cases? We kind of got this little issue with Jonathan Martin. Would you like to defend the team? And for the first time in my career, because it's against my religion to turn away work, I said, I've decided that I do not wish to commit career suicide, and I will not be taking that case, but thank you for asking. Because this is what's going to happen. And I told him this within 3 weeks of this story breaking. In about 6 months after everything settles, there's going to be a story on the front page of the Miami Herald, and it's going to start something like this. Cheryl Wilke, counsel for the Miami Dolphins, expresses the team's apology for the way that Jonathan Martin was treated as an employee, which is precisely what happened 6 months later. And for all of the people, which I know is not you, because you run a business and you understand this, but for all of the people who tried to say, well, we're football players, this is the culture of the locker room, this is fine, this is our culture, you can't tell us that. No, you are an employer just like any other employer. You pay people, you sign them, you hire them, you are an employer like everybody else. You are employers like everybody else as well. It doesn't make any difference. Well, we've always been an old boys shop. This is what we do. No, it does not matter. These are the kind of cases that are going on, and they're on my desk every day. Bullying cases are the trend. When it just doesn't work out, there are 2 reasons that it doesn't work out. Hopefully, it's that pay plan reason, or the policy reasons that we talked. It's objective. Written goals were not met after the employee acknowledged them. The written goals were provided a definite time goal to reach the goal. They didn't do it. It was clear that the failure to meet the goal would result in separation. So if you don't sell 8 cars, whatever your standards are, put them in writing, say that's what they're going to do. If they don't do it, you get the right to fire them. It's a performance-based goal. Easy peasy. Make sure you apply it to everybody equally. I don't care if they're blue, green, purple. They work there 6 months, 8 months. You can change that number. If you've been there less than a year, you have to sell 3 cars, 4 cars. Pick the number, but stick to it. Then you have the tough ones. These are the ones that litigation comes from. Okay, their personality, their intangibles. You can use a performance improvement plan. You really have to be nicer to everybody. Some of it is they're just mean, or they're just cranky, or they're just stubborn, or whatever. And training personality is so hard. Your employee handbook is your best friend. This is where you get into the policy. You're late, your clothes are disheveled, you're not treating the guests appropriately, you're not here on time, whatever it is. This is why you want the handbook, sir, so that you can use it on this side of the chart when things are not crystal clear, when they're not objective standards. Always use written confirmations, okay? You have violated policy number whatever on page 4. Next time you do it, it will result in a separation. Whatever it is, but put it in writing. Enforce the policies for everybody and separate sooner than later. You all are classic for this. It's kind of like that girl who dates the guy who thinks he's going to change. Here's the clue, they never actually change. Employees don't change either. So if you hire them and you think, oh, just 3 more months, it'll all work out, it'll all be fine, they'll change, probably not. Separate sooner than later. When you have to terminate, which is never pleasant, no one likes to do this. This is not, nobody likes to do this. But there is a process to it. Have all your paperwork together. Have their written termination, if you're going to do a letter of termination. If there's any benefit issues involved, have their COBRA package together. Have their last check, if you can. Have a list of what commissions they might be due if you've got sales pending, whatever it is. But have that all together before you sit down. Ensure there is 1 witness and 1 supervisor. Now, I don't care how you do this, but never terminate with 1. Just like you don't hire with 1 or interview with 1, you don't fire with 1. You always need a witness. I like to have the Jonathan Martin size witnesses, the 6'4", 3 whatevers, but it doesn't matter. Have a witness. Do not be afraid of the silent moment. And no offense to all the men in the room, but this is what tends to happen. You have to fire a lovely young lady that, for whatever reason, is just not doing her job. And she sits there, and you can see the tears, and you guys tend to be kind of suckers for this. But so they're sitting there, and they say, but, how am I going to pay my next car payment? Okay. Do not be afraid to say nothing. You do not have an answer for that question, so do not make one up. Do not try to be nice and say, oh, I'm sure I'll help you get another job. It'll all be fine. No, do not be afraid of the silent moment. Do not be afraid not to answer that kind of very personal question. Separate at the end of the day or at the end of the week. I do not do perp walks. I do not believe in them. I think that they're bad for business. If other competitors know that you fire people like this, you do not, in the middle of the day, in front of everybody, have a security person come and clean out their desk and walk them out in front of everybody, including customers. I think that even though you may feel like it, it is not a good way to separate. You separate with respect. You don't have to love them. You just have to get them out of there with dignity. If you have any reason at all to believe that you have a security issue, you have someone who has turned out to be not stable, and it does happen. You have found somebody who is not stable, and you are sincerely concerned about the safety or security of your customers, your employees, you. I have never once, And I don't care if it's Ottumwa, Iowa, or Chicago, Illinois. I have never once picked up the phone and called the local police department and said, I'm going to be separating an employee that I believe is going to be an issue. Could you please send someone over to be in the lobby? Never once have they ever said no. Sometimes they've given me a time, but never once have they ever said no. They would much rather help you escort out that dangerous employee than get the call 4 hours later that they've shown up at your house with a shotgun. Use your local resources. They are always happy to help. As an employer, do not deny or promise unemployment at the time of separation. Back to the young lady who's crying and you're saying, oh, it's okay, I won't contest your unemployment, you'll get unemployment. You have absolutely no control over that. Unemployment is paid by the state. In California, it's called EDD. In Florida, it's called unemployment. Sometimes it's called retraining benefits. It depends on your state, but you guys know what I'm talking about. The benefits that you get from whatever state when you are unable to work or when you've been separated. Do not make any promises. I have had employers who have unsuccessfully, gratefully, but I have had unemployers who have been sued for fraud, for making a representation that they were going to get unemployment and it was all going to be fine, and then they didn't get it. You don't control that. The state controls it. Be cognizant of any confidentiality or related employment terms. You know, in part of this handbook that you're supposed to have, it's supposed to say in there that your business processes, any information regarding the family who runs the business, personal information that they may find, that should all have a confidentiality clause. It should all say that if they violate that, that there's a certain amount of liquidated dollar damages that you can get. Make sure that you remind them that your business processes, your calculations of whatever it is, the business things that you all have used and worked so hard to create, don't walk out the door and go down the street to your competitor, not legally anyway. Provide only a neutral reference regardless of the reason for termination. A neutral reference is dates of employment and job title. He or she was employed here from this date to this date and they did X. I don't care if they left with roses and sunshine. Oh, hi.
Hello.
See, you're wearing shorts, so you must not be from a warm state because it's freezing in here. Okay, go ahead.
Minnesota.
Oh, see, you folks are just, see, I knew it. You know, you guys jog in shorts when it's 26 degrees out, yes. What can I do for you, sir?
As far as on the client list, all the salesmen keep names and address of the clients to do follow-ups and stuff. If you terminate them, I've told my employees in the past that we own the client list.
Of course you do.
All right, so I want to make sure I was correct on that.
Put that in your handbook. The handbook that some other crazy lawyer said you didn't have to have.
As soon as I get a handbook, yes.
Yes, you need to have it in there that your client lists are your client lists, and you don't care if it's their Aunt Sally or their next door neighbor. If they are a customer of the business, they are a customer of the business. They are your customer as the owners. And that is absolutely something that should be in each and every handbook. Here's the information that needs to be kept confidential. This is what we own. We own this process. We own this advertising campaign. We own these customers. We own this finance program. Whatever it is that you all have worked your whole careers to create, to make you unique and distinguish you from every one of you, that's what you want in your handbook. You don't have to describe it in detail, but you have to reference it. Did I have another question? Oh, yes, sir.
Yeah, I'm from Ohio, and I'm wearing long pants because it is cold in here.
I'm sorry. Why? What, you know.
But
if
anyway,
you need a pair of shorts, I bet the guy in Minnesota has an extra pair. They seem to wear them all the time.
Anyway, I should ask this question back. When we're posting the job, can we post that we will be doing a background check? Won't that kind of help accomplish the same thing?
Well, you can, but remember what that new regulation from the EEOC said. They get a little suspicious when you put it in the posting as opposed to the application. But if you're going to put it in the posting, as long as you designate that the posting is specifically for sales, where they're going to be touching cash, checks, or keys, then you're probably okay. Not my first choice. I would suggest it be part of the application process, but you can do it.
Okay, but somewhere before the interview.
I'm sorry?
Somewhere before the interview. Somewhere before the interview.
Yes, that's true. Yes, and you can do that. Yes, sir.
Does NIADA have a generic guideline for this handbook?
I do not know the answer to that question. Okay, then the answer is no. Yes, I do not know. I know that I've drafted about 6,000 of these in my career, but I thank you for saying I did not know if there was a standard one. Yes, sir.
To help him out a little bit, I plagiarized a large auto groups and
Oh yeah,
replaced their name.
being a lawyer, it's 85% plagiarism. So please go ahead. Yes.
No, that's what I did. I plagiarized the large auto groups.
Yeah.
I just
The
put
general
our
release
business
that I
name.
use, I may have borrowed from UPS several years ago. So yeah, go ahead.
So are you recommending also in job posting against earning potential? Like you can
Yeah,
earn up
I
to-
have to tell you, especially if you're in a tough state, if you're in Illinois or California, I mean, if you want to reference extraordinary earning potential without a number, I'm okay with that generically as a subjective concept, but don't put numbers in there. You know, anytime that they say, oh, you have the potential or you can earn $100,000, it sets up people to be disappointed. And then they look at you and they say, well, you said I'd be earning $100,000. Everybody reads that the way they want to. I never put numbers in there. Yes, sir.
With regards to the background check, it's my understanding, please correct me if I'm wrong, that you can not hire them, or you can choose not to hire them based on what comes back for the background check, if it's on the basis of what their job
Correct.
will entail, which is
Yes,
what you
sir.
said. Now, so with that, if they, let's say they're a sex criminal, has nothing to do with cash, theft, or any of
Mm-hmm.
that, you still can't not hire them on that basis alone. Is that
What is their
accurate?
job again?
Sales.
Oh, no, sales, they touch keys, right? They take people for test drives?
Right? Sure.
Okay, keys, you're done. You can have a background check.
Okay.
Easy peasy.
All right.
Yeah.
So you can kind of interpret with everything we
Oh,
do in
yeah,
sales.
and you guys are great. I've actually extended it all the way to porters, to the people who pick up the parts, to everything, even though those people wouldn't normally. But the rule says if they have access to keys, because keys are considered properties and there's special licenses that go with that, if they have cash, meaning that they work at the cashiers, they take cash or they whatever, checks, credit cards, you can do background checks on them. Or if they have check signing or check writing authority, then you can do background checks on them. Oh, no,
and
sex crimes, it doesn't make, I wish it
example.
made a difference, but I can tell you, and I know, listen, I understand what you're saying, but I can tell you seriously, it doesn't matter what the crime is unless you are running a school or a daycare center.
Right.
So if a felony is a felony is a felony according to this rule. So if you've got someone who's a salesperson and they're convicted of a sex crime or they're convicted of an advanced DUI, it's the same thing. The law looks at the same. You can say no.
Oh, really? Okay.
Yeah. They do not distinguish the felonies except for people who are around children or the elderly. So if you're going to work in a nursing home, you have to pass different kinds of background tests to have those jobs.
So to clarify, if it was a sex criminal, you can not hire them on that basis?
Absolutely.
Perfect.
Because they touch keys, and even though they have nothing to do with the keys and the cash, and it doesn't make any difference, you can still make the decision not to hire them.
All right. Thank you.
Contest unemployment claims based on misconduct and not performance. This happens all the time, especially with small, loyal employers like you. They come in, you've trained them, you've really got them really on their way, and for whatever reason they are disloyal and they leave, or they have performance problems and you're either forced to separate them or they voluntarily leave. Remember that the standard in every state except California, which has no standard at all, but the standard in every state except California is that the employee must have committed misconduct, not just failed in his or her performance in order to be denied unemployment. Let me give you an example. I represent AutoZone. AutoZone comes in and they hired a person who was supposed to do X, Y, and Z. He did it horribly. He was just awful. He had all the parts mixed up and didn't register anything right, and people were buying things and taking them home and they were wrong because he had all the computer stuff wrong. We fire him for performance. Okay. He's probably going to get, in 48 out of 50 states, he's probably going to get unemployment. The guy who takes $20 out of the cash register will not. Theft is misconduct. So keep those two distinctions. Don't spend a lot of time and money hiring lawyers to contest unemployment claims for performance issues. If you really want to contest an unemployment case, make sure that the basis is misconduct, not performance. All right, this is me. This is where you can find me, although most of the time I'm on the road or in really great places like Florence, Arizona. Have you been there? It's the end of the world, isn't it? Yeah, I think everybody should just go through, yeah. I have, as always, truly loved speaking to each and every one of you. Georgia always says that the best way to come back is to have some of you say some nice things about me, so if you would do that, I would appreciate it if you want me back. I can always narrow the topics, but thank you very much for being here, and have a great convention.